This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with Ryan Anderson a new book that he is a co-author of entitled What is Marriage? Man and Woman, a Defense. The other authors are Sharif Gerges and Robert George. Ryan Anderson is the William E. Simon Fellow at the Heritage Foundation and the editor of the online journal Public Discourse. His writings have also appeared in the Harvard Journal of Law and Public Policy, First Things, Weekly Standard, National Review, and the Claremont Review of Books, and he is currently completing his Ph.D. in political philosophy at Notre Dame. Ryan, welcome.
Thanks for having me. Happy to be with you.
Glad to have you. Let me ask you a basic question at the beginning. What is marriage, and why should public law regulate the institution?
Sure. You know, the way that we open this book is to say that the marriage debate is not about homosexuality, but it's about what marriage is. And to answer that question, we propose that there are two different conceptions on marriage on the table, neither of which is specific to either heterosexuality or homosexuality. That these two different views of marriage inform both heterosexual marriages as well. The one we call the conjugal view. This is the traditional view. We find it shaping Western law and Western culture going back to the ancient Greeks and the ancient Romans and up through the Enlightenment philosophers. This is a view of marriage as a union of both hearts and minds, but also bodies. And so it's distinctive. It's a comprehensive union. It unites spouses on all levels of their being. And that the sexual act that unites a man and a woman doesn't just allow their genitals to rub up against each other, doesn't just kind of allow for friction. It actually unites them into a single reproductive principle, a single organism. And that act itself is ordered towards and is apt for the reproduction of the species, the procreation of children. And so we say that this is a comprehensive union both in the act that unites the spouses, but then also in the good that the union points towards, which is the creation not just of any particular good, but the creation of an entire loci of good, new human life. And so we say that this then calls for comprehensive commitment. You know, if you're going to unite at all levels of your being, and if it's going to be pointing towards this comprehensive good, it also calls for comprehensive commitment, exclusivity, and permanence. The revisionist view, we argue, is where love is, in one philosopher's term, it's John Corvino, philosophy professor in Detroit, he says it's your number one person. What marriage is about your number one person. So it's mainly an emotional union. It's mainly an intense emotional union. It's your number one emotional union. And we argue that on that case, the traditional marital norms make less sense. It's not clear why it should be a monogamous union. That the number one, your number one best person, it's not clear why it can't be your number one and number two best union. It seems arbitrary from this understanding. It's not clear why it has anything to do with family life or generativity. And then it's also not clear, therefore, why it should be a permanent union rather than just a contractual union that lasts as long as the love lasts. If it's an intense emotional union, it should be governed by the emotion. And so in these two understandings, we can say this is why government would be interested in marriage understood as a conjugal union, but it really makes no sense if you're a believer in limited government to have marriage in the intense emotional union business. Because what we want to say is that the reason that government's in the marriage business isn't because it cares about my romantic life. It's not because it cares about the warm butterfly feelings that I get when I fall in love. It cares about children, and it cares about making sure that children are raised to maturity, are raised to be good citizens, in the least restrictive, least coercive way possible. And so how can it do this? It can do this by incentivizing men and women to commit to each other as husband and wife and to then take responsibility as mother and father for the children that their sexual act created. And that's why the government's in the marriage business, and it's in the marriage business understood as a conjugal union between sexually complementary spouses.
Let me ask you on the revisionist view. I mean, the way I see the public argument going, a lot of people advocating for that position also would attach permanence and exclusivity to marriage under their conception of it, no?
Well, some try. So one of the things that's interesting is that we point out both the attempts by revisionist philosophers and advocates to justify those norms, but also more candid members of the revisionist camp admitting that the norms won't make sense and that would be a good thing. And so we actually argue in the book that the more prominent view is that monogamy, sexual exclusivity, and permanency rise or fall with the conjugal understanding, and that the disagreement is whether that's a good thing or a bad thing. And a lot of the revisionists say, look, one of the great things about redefining marriage will be that straight couples can now learn from gay couples some of the virtues of a sexually open relationship. Traditionally, we've called that infidelity. We've called that cheating. And this was Savage in a profile in the New York Times titled
You mean Dan Savage?
Dan Savage, yeah.
Okay.
Yeah.
I mean, I think I've heard Andrew Sullivan make that argument.
Sullivan has also,
if I'm not mistaken. Yeah,
you're correct. We cite Sullivan and Savage and a couple other people who more or less want to say that we should get rid of any legal normative expectation that marriage should just resemble contract law. And so, marriage is going to be between 1, 2, 3, 4 or more people. It can be sexual or or platonic. It can be sexually exclusive or sexually open. It can be permanent or it can be temporary, and that the terms and the conditions should just be set by the consenting adults who enter it. Well, in our understanding, that's more or less the abolition of marriage.
So let's think sociologically here. It seems the ratifying of same-sex marriage or the conferral of marriage upon same-sex relationships will be sociologically insignificant. And one thing that leads me to that position is jurisdictions that have legalized it, Canada, Scandinavian countries. I'm thinking, from what I've read, there's an initial rush to register partnerships in the first few months, the first year. And then it drops off after that. It doesn't stay, even or even increase, but it does drop off, which leads me to think it's not something that most, or maybe that it's not going to be something that is significant and lumpy within society. And so if that's true, then why does that really matter? I mean, and even if thinking about scenarios like polyamory or polygamy becoming legalized, I mean, even then, it doesn't seem to be it's going to be a significant thing. So what's the harm?
Yeah, that's a great question, because behind that question is a premise that the concern about harm is primarily about same-sex couples themselves, and that somehow same-sex couples are going to be committing harm. That's not the argument that we make in the book. The argument that we make is that redefining marriage changes the public understanding of what marriage is, and that if you were to redefine marriage to exclude the norm of sexual complementarity, then that the other three norms of marriage, monogamy, exclusivity, and permanency, make less sense as a rational matter. That the reason you get monogamy, for example, is because not that there's anything special about the number 2, but because it's a man and a woman. That's how you get there. And that if it's a conjugal union, that explains why the exclusivity that spouses pledge is sexual exclusivity. And if it's a fruitful union, if it's oriented towards reproduction, that can help explain why it's a permanent union. Once you eliminate that first norm from the public understanding of what marriage is,
meaning conjugal,
we are the sexual complementarity.
Okay, sexual complementarity.
Yeah.
Okay.
Then we argue that will change the public understanding of what marriage is, and as law teaches, it shapes culture. Culture shapes belief. Belief shapes action. And we make a parallel to no-fault divorce. One of the things that the introduction of no-fault divorce laws did was it allowed a spouse to file for divorce for any reason or for no reason at all. Whereas in the past, you used to have grounds for divorce, and you would cite fault. You would assign fault to one of the spouses. They cheated on me. They're abusing me. They're not living up to their end of the bargain. And so it retained an expectation that marriage was meant to be a permanent union. But with the introduction of no-fault divorce, what Jennifer Roback Morse calls unilateral divorce, it changed the expectation that marriage was to last as long as the love lasts. And now we can see with 50% of marriages ending in divorce that the law shaped culture, culture shaped belief, belief shaped behavior. The other thing that we point out as far as some of the harms is that changing the public understanding of marriage will also make it much harder to send a signal that fathers matter. the original marriage movement, the marriage movement that took place in the 80s and the 90s, had nothing to do with same-sex marriage. It had nothing to do with gay rights. This wasn't on anyone's radar screen. It wasn't on anyone's agenda. The original marriage movement was about combating the divorce culture, the cohabitation culture, the out-of-wedlock childbearing culture. It was about helping to persuade men that they should commit to the women that they had made children with, and that they should commit to the children that they had made. And so you get activists writing books with titles like Fatherless America, Confronting America's Most Urgent Social Problem. It's really hard for the law to send a signal that fathers matter when it's redefined marriage to make fathers optional. And it'll then be really hard for institutions of civil society to send that message because it would now be deeming that those who hold on to this traditional view of marriage are the functional equivalent of bigots. And we've already seen in the state of Massachusetts, the state of Illinois, and here in D.C., where I am, that Catholic Charities have been forced to shut down their adoption agencies because they wanted to place kids with moms and dads, and the state said no. That's a discriminatory view. You have to place kids on an equal footing with same-sex couples and with opposite-sex couples, or else we won't give you the certificate for running an adoption agency. So those are the consequences. It's not quite the one-to-one correlation as if, this gay or lesbian couple is going to cause harm. It's that it's going to, law shapes culture, culture shapes belief, belief shapes action.
Let me ask you a no-fault divorce. So, and people don't realize what a sea change this was in the development of marriage law in the West. And, what developed my thinking was actually reading John Witt's book on the development of law and marriage law in the West, moving from the Roman Empire really up through. He cuts it off in the Anglo-American democracies, I think in the 70s and the 80s, because that's really the last major movement, which is no-fault divorce. But what the effect of no-fault divorce is you've privatized the institution, whereas always those entering into marriage, it had been known that you have public duties and responsibilities. And in a way, this is why just even the marital ceremony is a public thing. You're standing before a community, acknowledging these new burdens and rights that you're receiving. So, but we do have no-fault divorce, and it's not going anywhere. And even these movements you mentioned, the marriage movement in the 80s and 90s. I can remember there was a effort to try to reinstitute fault divorce, or at common law, the 3 A's: abuse, abandonment, and adultery. And that really went nowhere. I think Louisiana has an optional marital structure for that, but very few
covenant marriages.
Marriages, very few couples register under that status. And so if it's not going anywhere and you have privatized it, it seems practically impossible under that understanding to deny it to same-sex couples, to that private institutionalization feature.
Well, I don't think so, because I think this is that's the equivalent of saying that you have a grease fire in the kitchen, might as well burn down the entire house. Yes, you're right that marriage law has gone wrong over the past generation, and that the marriage culture has been damaged over the past generation. The question facing us right now is, do we double down on all of those mistakes and all of the harms that those mistakes have caused by redefining marriage even further away from the truth to now exclude the norm of sexual complementarity, or do we hold the line here and we try to continue to make incremental, marginal improvements in both law and culture? It seems to me that it doesn't make sense to say that because there's already been damage to marriage, we should go all the way and drive the final nail into the coffin in redefining marriage.
Let's think about it this way. I recently read Charles Murray's book, Coming Apart, and Kay Heimowitz has written about this, how marriage is actually still pretty intact amongst the upper middle class, amongst people with college graduates who marry. Divorce is the exception; it's not the norm. Children born into those marriages tend to grow up with both biological parents. So clearly, something is evident there that's holding it together. That's not in, say, the bottom third, where really, as Murray argues, this is actually becoming the exception. The marriage culture really does not exist, and of course, there are a lot of things going on there. But so clearly, there is something there, and I want to try and work in Jonathan Rauch's argument, which is important. He's a very, he's a wise observer, I think, of a lot of public matters. He's also defended a lot of Christian groups on college campuses who are having rights of association basically taken from them. He's defended them precisely on the grounds that minority voices are needed to help a culture thrive. He's actually argued that this would be a good thing for marriage itself, to legalize same-sex marriage. And in particular, and kind of paternalistically, he argues for same-sex couples, it would be a good thing for them.
Yep, we address that in the book. We have a chapter that responds to the so-called conservative case for redefining marriage. And, we respond to, we think Rausch is the most eloquent, the most thoughtful, the most reasonable of the people making that case. I think all three of us, Sharif, Robbie, and I, have been in conversation with him at various points over the past couple of years at different conferences and summits and things like that. And, we engage his argument precisely because we think it's the best one and it needs to be taken seriously. But we think that argument fails. We agree that one way or the other, the norms of the two institutions will come to be more similar to each other, but rather than traditional marital norms being grafted onto same-sex relationships, we think the norms of same-sex relationships will come to influence the behavior of traditional marriages. We don't see how, once you redefine marriage to exclude sexual complementarity, that any of the other traditional marriage norms make sense as a requirement, as a principled requirement of the nature of the relationship. They make sense, if it's an optional add-on, if you choose to pledge permanency or exclusivity or monogamy, but it's not clear why the relationship just as such calls for those pledges. Sure. And as we point out in the book, we kind of go through chapter and verse, dozens of the leading LGBT scholars and activists who openly admit that they're not just for same-sex marriage, they're for going beyond it. So one of the statements we cite is Beyond Same-Sex Marriage. It's signed by 300 scholars and activists, including prominent Ivy League professors, Kenji Yoshino at NYU's Law School, Cornel West at Princeton, more or less calling for the legal recognition of multi-person households. We also have people saying that sexual outlets outside of marriage can benefit the health of the relationship, that permanency is kind of a straitjacket. We shouldn't make those types of pledges for life. We should make more temporary pledges and then reevaluate. Whether or not those things make sense for gay or lesbian relationships, I can't say. I do know that they won't make sense and they won't do well for marriages precisely because children need stability and they need the commitment of a married mother and father. So from the state's perspective, the reason the state's in the marriage business is to get men and women to commit to each other as husband and wife and to then take responsibility for their kids as mother and father. Because when this doesn't happen, government grows. Government grows in its welfare agencies, government grows in its judicial activities, government grows in its criminal justice activities, prison populations grow, poverty rises, mobility falls. And this is exactly what you see during the 80s and the 90s when the marriage culture was more or less collapsing, and we have the rise of the welfare state, the rise of our prison populations, increase in poverty, decrease in mobility.
Let me ask you, I was wondering, so this is kind of the next part of questions I want to ask you. Thinking about marriage in the state, marriage in public law, why couldn't you, in effect, privatize it and have people make a series of contracts around the marriage and then let courts enforce those as need be and kind of, just reach around this very difficult debate and let private institutions, in particular churches and religious institutions, really step forward and have to assume greater accountability and demand greater accountability of the people because, right now what you have, I think, is we have a very loose conception of marriage. And I think this does count in favor of your argument. I think the no-fault divorce has had a very powerful public effect. And clearly, we're looking at public opinion polls of people in their 20s and 30s right now. Increasingly, what we see is marriage is kind of an option, the way they look at their future lives. Children are definitely an option within the marriage, which is a sea change in the way people think in this country on these subjects. And so couldn't that actually be beneficial if we have these private institutions really step up and are in fact empowered by transferring this role from the state to their agency? It seems to me that would be good. And also, and in effect, we kind of step out of these very difficult situations that are coming, which I think are going to be a train wreck for religious liberty and rights of conscience, where people who do hold to the conjugal view, seems to me, are increasingly going to be moved aside. And we can talk about early examples already of this, which I think are very disturbing.
So I think that question rests on kind of two assumptions that I'm not sure we can make. The first is that it's a trade-off, that it's an either-or. It seems to me that we want both, that we want the institutions of civil society, churches, synagogues, mosques, to promote marriage and to take more responsibility on making sure their members take marriage seriously and they commit to each other and that they live out the norms of marriage. But that we also want the state to do this, that the state has a role in playing and shaping culture, and that it seems to me that the message, if the state got out of the marriage business, would ultimately be one of continuing to weaken the marriage culture. This wouldn't send a signal to citizens that marriage really matters. It would send a signal that marriage isn't all that important, and so we're no longer observing it. The second point is that is it even possible for the state to get out of the marriage business? And it seems to me that if marriage is understood just as an intense emotional relationship, your number one person, then the state doesn't need to be in that business. But if marriage is about generativity, and if it's about the state finding a way in the least coercive way possible to make sure that children are cared for, because look, the sexual desire that allows for the creation of children is not sufficient to compel the man and the woman who created that child to actually raise the child, and to raise the child in a way that's best for the child. All the social science we have show that kids do best when raised in an intact, married family between their married biological mother and father. That every other family structure that has been studied, children tend to do worse, on average, for the most part. This isn't to say that single mothers aren't heroic, but it is to say that kids raised in single mother houses, on average, tend to do worse. Children of divorce, on average, tend to do worse. Children in cohabitating relationships tend to do worse. So if the state has an interest in ensuring that these kids turn out well, the state can either A, try to raise the kids themselves. The state can B, pick up the pieces after the marriages collapse with an increased, bloated welfare state. Or the state can C, non-coercively incentivize men and women to commit to each other and to then take responsibility for their kids.
No, I think you make a good point too. A lot of people aren't aware, unless you actually go through it, how authoritarian these local family courts are with regard to marriages that have broken up, and actually ordering, setting specific dates and times of when children will be transferred from the father to the mother, et cetera. But of course, they really have to be, in a sense. They have to really step in and be some sort of providers of order and guarantees in the lives of these children when things have kind of broken down at that level. And not even, you just think about how bad it can be at times, and who is there to pick up the pieces. A lot of times it is just the government that's there. So I think that's a powerful point. I wanted to also ask you, with the relationship to government and marriage. I mean, you cite two sociologists, David Popenoe and Alan Wolf, who looked at Scandinavian countries and I assume went beyond correlation and found some sort of causative relationship between decline of marriage and family life and the size of those governments. Could you talk about that? I was interested in that.
Yeah, well, so we point to their studies of the Scandinavian countries. We also point to some studies here in America. So there's a Brookings Institution study that we cite that shows that between, I think it's 1970 and 1996, breakdown in the marriage culture. So they're talking here about single parenting and divorce. And they cite, I think the figure is $229 billion of federal welfare expenditures can be directly attributable to that. We cite a study with Brad Wilcox from the University of Virginia showing that, an important factor for the economic wealth of a nation is the health of its marriages. He goes through the social science of that here in America. We point to a more recent study, I think it's 2008, a Utah State scholar who found that each year local, state, and federal governments divorce alone costs something like $33 billion. And just the welfare programs that have to pick up the pieces and the judicial programs that Jennifer Roback Morse cites a case in which a judge had to pick which prom dress a girl was going to wear to her senior prom because the parents were fighting over this. So it does point out that if you want to have limited government, if you want to have self-government, that the first institution that needs to govern itself needs to be the family, and that the state can either define the family up front, marriage is man and a woman, exclusive, permanent, monogamous, or it can then define it at the back end when the spouses go through divorce court and go through custody hearings and go through alimony hearings. And when, particularly, I like to make this point with libertarian-leaning economists, is that there's a big externality with respect to adult sexual behavior. A man and a woman can consent to have sex, but they might not necessarily consent to take care of the child that results from that sexual encounter. Who's responsible for that child? In the same way that the child now exists, but is to a certain extent an externality of consensual adult behavior, and that it seems to me that the state somehow needs to find a way to make sure that that life is cared for, and that promoting marriage is how the state does that best.
It seems also, something that I think about, and it's related to this, is just the question of demography. And we've operated for decades now under the assumption of overpopulation, but I think it's very clear now to everyone we do have an underpopulation problem. And we see this part of the debates over our entitlement welfare state system. We really don't have the same population increase year over year to support those level of expenditures. A lot of problems going into the entitlement problem, but a lot of things factoring in. But demography is one of them, and it would seem right if marriage declines, has something people do, has something people stay committed to, that the number of children being born will continue to decrease, but also those that are born are raised in partnership with the state. I want to ask you, there's a quote you have from David Blankenhorn I wanted to read because it really goes to this issue that we've touched upon about constructivism, or not just the revisionist view of marriage, but constructivism. This is something we create for our own social needs. It's not, you're arguing that it's like truth. It's there. It's a part of human nature. It's a part of our social nature and the things that we need to live well. It's something that we need. And you cite this quote from David Blankenhorn. David Blankenhorn has a way to respond to the constructivist view, and I just wanted to read it and get your reaction. Here it is. If you've been trained, as anthropology field researchers typically are, to begin at the beginning, to start with the most fundamental issues, you will report a cluster of related facts. Humans are social. They live in groups. They strongly seek to reproduce themselves. They are sexually embodied. They carry out sexual, not asexual reproduction. They have devised an institution to bridge the sexual divide, facilitate group living, and carry out reproduction. All human societies have this institution. They call it marriage. Hello, Ryan?
Yep.
I guess my question really to you is, in thinking about that, okay, so that's one reply to the constructivist position. Although I suppose marriage now in the 20th century looks very different from how it did in the 19th century, the 18th century, 17th century. There are a lot of changes that go on. There are property laws change, economic purposes change, subjective expectations on what you're getting into change. And yet, you're arguing there's something core that remains.
Yep, that's exactly right. So to the Blankenhorn quote, what we want to point out is that it's a remarkable fact that in recorded history, if you look at cultures vastly different from our own, different property regimes, different inheritance regimes, different ways of regulating what we would call civil rights or protecting civil rights, you find something remarkably similar to the institution that we call marriage today. And that while it changes around the periphery, the core of the relationship, that it's a union of a man and a woman intended with some amount of sexual exclusivity and fidelity, oriented towards family life and reproduction, that really remains constant. That more or less every society that we have a record of, so every society that has lasted long enough to leave a record of itself, has regulated the sexual relationships between men and women. And there's only one kind of answer for this. The remarkable fact that this has existed more or less everywhere, and it's that the political community needs to ensure that reproduction takes place in an orderly way.
Now, you also cite permanence and exclusivity. So if marriage being defined by the conjugal union by coitus it seems to be a constant, permanence and exclusivity are not. You say. I mean, they're highly prevalent, but they're not nearly as universal. So why is that? That's interesting, I thought. And of course, right, I mean, we do have a lot of cultures and civilizations built on polygamy. And it's funny to think, Thomas Aquinas really struggled with, could you even rule out polygamy on the basis of reason? Or he ultimately does, but it's a complex argument.
Yeah, I mean, so the way we think about this is you mentioned Aquinas, so we'll bring up when he talks about the Germanic tribes and robbery. And, he's talking about the natural law, and he says, theft is everywhere wrong, but that some people have applied it only as like theft within our community, not theft outside of our community. And his point here is that, it's an Aristotelian point about focal cases of law. And that, there's the focal case and then there are more distant cases. And that we argue that for marriage, it's really the male-female part that's most focal, and that the other norms of marriage build upon and follow from that point, so they become more distant. So that even when you had instances of polygamy, it was still a union of Jim and Jane, Jim and Susan, Jim and Barbara, Jim and whoever else, right? So that each one of those was a conjugal union. Each one of those was a sexual complementary union between a man and a woman, oriented towards reproduction.
Okay.
The norm that follows from that of monogamy wasn't as well grasped and as well practiced and enshrined in law. But the focal aspect of it's about uniting a man and a woman in a sexual reproductive relationship, that was grasped. And to a certain extent, I think even from within the biblical tradition, when Jesus is asked about divorce, and Moses granted us a bill of divorce, you can even look at the rhetorical strategy of Jesus here. He says, yes, Moses granted you a bill of divorce because of the hardness of your heart. So the hardness of their heart, part of the natural law has been blotted out. But from the beginning, it wasn't that way. The passage that is referenced in from the beginning is going back to the Genesis account, that it's from creation, which points that this is something natural. It's not a revealed, it's not a sacramental or supernatural understanding about marriage. When Jesus says that, marriage is a permanent institution from the beginning, he's talking about from creation, which within kind of the Western Judeo-Christian natural law tradition, that this is it's part of the nature of the thing.
Yeah, I want to ask you. You point to this with regard to the revisionist view. Now, your argument is that ultimately their position that the question of what is marriage is that it's a very intense emotional union, ordered around primarily romance and deep commitments. So okay, that's the position. But of course, if that's true and it's not conjugal, then what would be the response to polygamy, to polyamory? And so I'm thinking, in one sense, it seems to me there really isn't a response. And it seems to me in a lot of debates that I've seen, public debates, this question gets asked, and the response is really just to kind of feign incredulity or to ask, well, it's just not really in the cards in this country. It's not something that's really possible or practical. Despite, our own heritage, which actually was, going back to the 18th century or the 19th century in the Mormon or early Mormon religion. So, talk about that. And also, it seems to me there is a rational reason, even if we were to confer same-sex marriage, to keep it to two people. And then one of which would just be orderly life with orderly predictions for children, that they could regulate their life around that better.
Yeah, so, we're still waiting to hear what the principled reason is for limiting marriage to the union of two people once you exclude the norm of sexual complementarity. We've placed this challenge to the revisionists in print in our Harvard Journal of Law Public Policy article. We've placed the challenge in the book. We've placed it in the series of lectures and debates that we've done at FedSoc chapters across the country, and we have yet to hear a persuasive response. And not only persuasive, we've yet to hear a response from most people. Most people seem to just concede the point that there's no principled reason. But if there's no principled reason, then you're saying that those marriage laws would be just as unjust, they would be just as arbitrary as they claim our current marriage laws are. So if it's unjust and it's arbitrary to say that marriage is between a man and a woman, it seems to me that the same logic would apply, that it's unjust and it's arbitrary to say that marriage is the union of two people. And if that's the case, and if you want to be governed by the rule of law, or rule of law is, it's governed on principle, right? There's some principle that the law reflects. What is the principle besides just a sheer preference for the number two?
No.
The sheer preference for the number two doesn't seem to be any different than a sheer preference for men and women, if you're going to argue it on the revisionist grounds. Whereas on our understanding of marriage as a comprehensive union founded on conjugal union, there really is a principled basis for why you would single out this type of union as different and distinct from other types of unions, leaving other types of unions people free to form those. So there's no ban on gay marriage. Two people of the same sex can live and love how they want to. Liberal churches can bless their relationships as marriages. Progressive businesses can give them benefits that they give to their married employees. If people want to live that way, businesses and churches want to do that. I mean, at stake in our current debates is about redefining a public institution and then using the force of law to coerce non-compliant businesses and individuals into recognizing these sorts of relationships as marriages.
I suppose on the point of polygamy, I've thought that really the big test will come, I would think, from nations in Europe with the Muslim immigration they've had, where this is a norm, at least in some parts of Islam, and that they would has more and more European nations. I don't know how many have at this point. Britain might be interesting, which looks like they're going to go in that direction. That those would be the first places we see these public appeals made. I don't know if you've looked into that or what you think of that. I wanted to ask you here at the end, just following up on the conjugal view of marriage, are you saying, with regard to children, is that an integral part of marriage, or is this something marriage is naturally ordered to? I mean, there's an important distinction there, and I just want to be clear on it.
Sure. We argue that there's an intrinsic orientation, there's a natural ordered basis within the relationship, so that an infertile couple is married. We think the infertility objection is very short-sighted. It's a debater's point that the law has always recognized that an infertile marriage is a real marriage, whereas an impotent marriage can be annulled because it was never consummated. An infertile couple is still able to form bodily union. They're still able to unite in a comprehensive, organic way, and that the type of union that they form is of the sort that is naturally fulfilled and is naturally oriented to reproduction, which is why no one's surprised when 9 months later a man and a woman who thought they were infertile have a kid. Right? A lot of times infertility is misdiagnosed, or it's later in life as you're going just before menopause. A bunch of eggs might drop and you might get pregnant as a result. Then, there are various ways of seeing that the type of relationship that is formed is still of the sort, it's of the type that's naturally oriented towards procreation, and that's uniquely apt for it. Because one of the things we point out in the book is that just as men and women are different sexually, so that they can form a union, so too mothers and fathers are different, and that they form different types of relationship with children. So that there's no such thing as parenting in the abstract. There's mothering and there's fathering, that this is distinct and complementary, and that kids do best, on average, when they have the access, the love, the care, the attention of their mother and their father.
Well, Ryan, I think in conclusion, the trial judge, at least the federal trial judge that ruled there was no rational basis for the defense of Proposition 8, I think should read your book for whatever we might think ultimately on this question. It seems to me you've clearly made a rational, defensible argument. Thank you for talking with me today. The book is What is Marriage? Man and Woman, a Defense. Ryan Anderson, one of the co-authors, along with Sharif Garrigus and Robert George. Thank you for being with us.
Oh, thanks for having me.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.